All right, welcome everyone to our latest ALTA Insights webinar. These are free presentations we offer on issues important to title and settlement professionals. I'm Jeremy Yowie, ALTA's Vice President of Communications, and today we've got a great webinar that's going to dig into RESPA and offer some tips on how to set up compliant marketing agreements and business structures. We had a great turnout with registration. We had over 600 people register for today's presentation. Before starting, I do need to touch on the housekeeping items we always review. Everyone's lines are muted for today's discussion. Anytime you have a question, submit them in the questions box. We'll hold a little time for Q&A at the end of the presentation. Today's webinar is being recorded. You'll get an email with a link to the recording tomorrow. And like all of our other webinars, they're all archived on ALTA's website at alta.org/webinars. That's alta.org/webinars. You can also download a copy of today's presentation from the handout section. Do need to thank SoftPro for sponsoring today's ALTA Insights presentation. And before introducing today's speaker, need to play a short message from SoftPro. Okay, all right, welcome back. All right, thank you, SoftPro. And now I will introduce today's speaker as soon as I can move the video off to the side here. And I will hand it over to our speaker. All right, joining us today, we have the luxury to hear from Holly Bunting. Holly is a partner in Mayor Brown's Washington, D.C. office and a member of the law firm's Consumer Financial Services Group. She practices in the areas of residential mortgage banking and consumer finance, focusing on federal and state regulatory compliance and enforcement issues. Holly represents companies in our industry, title insurance, as well as mortgage lending and real estate industries on regulatory compliance matters. And Holly, I will make you the presenter, and we can get this RESPA train fired up.
All right, great. Okay, just to confirm, you can see those slides, correct?
We got it.
All right, great. All right, good afternoon, everyone, or good morning, depending on where you are. Thanks for joining us. In my discussions with Jeremy, we thought that now would be a good time to do a refresher on RESPA, make sure folks are keyed into what those requirements are, but then also focus on what the requirements are for forming and operating a compliant marketing services agreement and a joint venture. So just quickly, what we plan to do for today, we will do a quick RESPA refresher, and as it relates to the prohibitions in Section 8, we'll focus on the Section 8C2 exception, which permits payments for goods or services, and then talk about tips for forming and operating compliant marketing services agreements. Then we'll switch to Section 8C4. That's the exception that permits affiliated business arrangements. And then tie off our discussion on attempts for forming compliant affiliated business arrangements. So let's start with section refresher. Is the screen moving for you?
It did not. It's still an introduction slide.
Okay. There we go. Okay. Section 8, of course, is the provision of RESPA that prohibits kickbacks and fee splits. And it's one of the more important and controversial statutes that affects the settlement service industry. For one, it completely defies business logic. To the extent that someone is referring business to you, the natural inclination is to reward them for that. But that's where RESPA becomes a problem. And there's also significant consequences. Section 8 includes criminal penalties for violations, which includes up to a year in jail or $10,000 fines. But now that the CFPB is in charge of RESPA, there's an additional of enforcement penalties that they can enforce or apply for violations. And then, of course, there's a private right of action. Consumers can sue and if they're successful, be awarded up to 3 times the cost of the settlement service as part of the damages under Section 8. When we talk about Section 8A, that's your anti-kickback provision. And the idea is to eliminate abusive practices that were driving up the cost to consumer when kickbacks were being provided. And so when you think about Section 8A and whether something is a violation, you should think about 5 particular elements. Section 8A says that it's illegal to give or receive anything of value pursuant to an agreement or understanding to refer settlement services in connection with a federally related mortgage loan. So let's talk about each of those elements quickly. We'll go in reverse order. So the first is a federally related mortgage loan. To have a violation of Section 8 of RESPA, you need to have a federally related mortgage loan as part of the transaction. And that's essentially any loan that's secured by a 1 to 4 family residential property. Doesn't matter if it's fixed rate or adjustable rate, first lien, second lien, refi, purchase money, all of that gets captured under this definition. It does not include business purpose loans. So if it's a commercial loan, if it is a loan on a single family property that's being purchased strictly as an investment property, it doesn't cover that. And of course, if it's a purchase that involves all cash, that element is not present. Second is settlement services. This is a broad definition. It covers anything done by title agents, attorneys, closing agents, mortgage brokers, lenders, appraisers, surveyors, homeowners insurance companies. Essentially any service that is needed and paid for as part of the closing of a loan transaction is going to get covered under that definition. You need a referral. Again, an incredibly broad definition from a RESPA perspective. Any conduct or activity that affirmatively influences a person's selection of a particular settlement service provider is going to meet that definition. So you don't actually need someone to say, I'm going to refer you to ABC Title. If there is any conduct that affirmatively influences that consumer selection, that's going to meet the definition. You also need an agreement or understanding. This is a really incredibly easy element to meet because it doesn't have to be in writing. It doesn't even have to be verbalized. If there's a practice or a course of conduct where there is an understanding that a thing of value is being provided in return for a referral, that's going to meet that element. Finally, you need a thing of value. Again, the theme with RESPA is it's an incredibly broad definition and it's virtually any consideration that's being provided. It could be money, it could be property, it could be a chance to win something in a raffle, it could be technology, it could be sporting event tickets. Any consideration is going to likely meet that definition. So when you think about these 5 elements, the important part to remember is that all 5 of them must be present. If you're missing any one of those 5 elements, then you don't have a Section 8A violation. So for instance, if you have all cash transactions and there's a referral fee being paid, you're missing an element, and so it's not going to violate Section 8A. If you have referrals that are taking place in connection with settlement service business, but there's no thing of value being provided in return for that referral, then again, an element is missing and you don't have a violation. So when you're thinking about your own business operations and the various strategic alliances or arrangements that you're trying to put together, think about these 5 elements and whether you might have a RESPA issue. There's also Section 8B of RESPA, and this is often the provision that doesn't get a lot of focus, but it's equally important because the same penalties are applicable here. This is the part that deals with the splitting of unearned fees, and the statute says that no person shall give, no person shall accept a split or a percentage of a fee in connection with a real estate settlement service other than for services performed. Referral is not an element for Section 8B. So if you've got an instance where you are splitting a portion of your title insurance premium with another party, that could violate Section 8B of RESPA unless the party that's receiving that split is performing services in return for that. So again, just something to be aware of when you're thinking about how your business intertwines with RESPA. There are exceptions. So Congress certainly recognized that there would be instances as part of typical business operations where paying a referral fee would be okay. I'm not going to go through all of these. You can see them on the screen here, but to highlight a couple of them, the second one here, it's the Section 8C1B exception that permits a title underwriter to pay its title agent for services performed in the issuance of a title policy. This is the exception that permits the premium split between the underwriter and the agent in any amount, and that exception makes that acceptable from a RESPA perspective. There's also the cooperative brokerage agreement exception that permits real estate brokers to share their commissions for referrals. There's also the 8C2 exception. This is probably the most popular RESPA exception because it really underlies most of the strategic alliances that exist out there, that permits bona fide reasonable payments for services performed or goods provided. And then, of course, the affiliated business arrangement exception, which permits profit distributions to owners of a business, even though they're making referrals to that business. And of course, we'll get into those in more detail. So let's do that now. Let's dive into Section 8C2. I mentioned that this is probably the most widely used exception to RESPA because it comes up in a variety of ways from a goods or services perspective. But it's also the exception that's gotten a lot of attention over the last several years since the CFPB took over for RESPA. You can see the statute there quoted on the screen. So nothing in Section 8 shall be construed to prohibit payments to persons for bona fide compensation for goods or facilities provided or services performed. In June 2015, the former director of the CFPB essentially took the position that Section 8C2 wasn't actually an exception, that to the extent that there were payments being made for services, if there were referrals also present in that arrangement, then you couldn't rely on the services exception. That, of course, was a new and different interpretation that the industry had not dealt with before from a RESPA perspective. This did go into litigation. One second, I just want to make sure the screen is working with us here. It did go into litigation. The DC Circuit, as part of the PHH decision, considered whether or not Section 8C2 was in fact an exception. And the decision was that this is not even a close call, that there's explicit language in the statute that says nothing shall prohibit those payments. Bona fide payments means reasonable market value. And even if parties are engaging in referrals, you can still take advantage of that exception. And that's essentially what HUD's position had been all along on Section 8C2. When that was appealed in the court in January 2018 affirmed that decision and that perspective under RESPA. All right. So the court essentially endorses HUD's two-part test for Section 8C2. And again, when you're thinking about putting together a services arrangement or an arrangement for goods, it's, this is the two-part test to keep in mind when you're thinking about compliance. First, are there goods and services? They need to be actual, which means the services need to actually be performed. They need to be real. They should be necessary, meaningful, useful services to the party that's paying for them, and they need to be distinct. They should not be duplicative of services that the party you're paying is already performing. And so if those three characteristics are met, then I think you can feel pretty good about goods and services. You also need reasonable market value. That's your second part. The payment that's made for services has to be commensurate with the value of those goods and services. Anything that exceeds that fair market value will be considered a referral fee. So that excess amount will be considered a referral fee. So it's always important to make sure you're comfortable with the value. Of course, marketing services agreement is a perfect example of where 8C2 was applied in the compliance context. And of course, a marketing agreement is an arrangement between service providers where one is paying another to advertise it to its customers. Typically, you'll see them between lenders and real estate brokers, or title companies and real estate brokers, or even title companies and lenders, where you're paying a fee for those advertising services.
Hey, Holly, is the slide transitioning?
Yes, it just did.
Okay, which should be on slide 16?
Yes.
All right, we're still seeing 12.
Oh, goodness. Okay. Well, let me see.
If it's not showing, I can always share my screen. I've got it up.
Well, I have a window that says move this window away from the shared application.
Yeah, something paused the sharing.
Okay, sorry about this, folks. Let me see if I can navigate.
It's a metaphor for compliance with RESPA. There's always wrinkles.
Indeed. Okay, Jeremy, maybe it makes sense for you, for me to hand it back to you to advance the slides.
Sure.
Okay.
All righty. You see
Okay,
it there?
perfect. Yes. So we went over the two-part test. If you could advance. We talked about MSAs, and then do the next slide. We should be caught up. Okay, great. So one of the things that has been frustrating about marketing services agreements over the years is that we've had very little guidance from regulators about what to do to put those together compliantly. HUD in 2010, when it was still responsible for RESPA, issued an interpretive rule analyzing marketing services agreements between real estate brokers and home warranty companies. And that was really the first time we got any concrete guidance about what the regulators would be looking for. When we transitioned RESPA to the CFPB, we had some enforcement actions related to settlement or to marketing services agreements, but then Director Cordray issued a bulletin, a compliance bulletin in 2015, which essentially took a pretty rough approach as it related to marketing services agreements. The bulletin was described as intending to describe the risks imposed by MSAs, but ultimately it didn't really provide any guidance about structuring them compliantly, and mostly was just issued, I think, as a scare tactic to let folks know that the CFPB didn't like MSAs. Now that we are a few years removed from 2015 and from direct record rate, the CFPB issued some FAQs in October 2020, and they also rescinded that compliance bulletin. So all of the guidance, so to speak, that we had gotten in 2015 is no longer applicable. And now we can look to these FAQs that the CFPB issued related to marketing agreements. Essentially, when you dive into those FAQs, the CFPB effectively affirms that they are permissible under RESPA as long as they are carefully constructed to meet the requirements of 8C2. And of course, the CFPB knows that it's going to be incredibly fact specific, and that is certainly true when it comes to these kinds of arrangements. And so, while one may be acceptable, a slight change in the facts may make an MSA unacceptable from a RESPA perspective. The FAQs also reinforce those Section 8C2 requirements. The CFPB notes that a lawful MSA involves services that are actually necessary and distinct, what we just talked about, and that those payments are a fair market value. Next slide. One of the things that often becomes an issue with MSAs is, are you paying for a service or are you paying for a referral? And based on that 2010 guidance we got from HUD, we know that any advertising service performed under an MSA needs to be directed to the general public. And so the CFPB gives us a couple of examples to help make that distinction between actual service and a referral. So in their example, a referral includes directly handing clients the contact information of another settlement service provider that happens to result in that client using that other settlement service provider. I like to call this direct to consumer solicitation. So whether it's handing business cards or brochures or just having a conversation with consumer about a particular provider, that's going to be referral. It's not going to be considered a marketing service. The example that the CFPB gives us on marketing service is essentially advertisements in widely circulated media. Jeremy, if you wouldn't mind going back one more slide, going back a slide.
Yeah, sorry about that.
They give an example: newspaper ads, trade publications, websites. And again, I think that's a reflection of this concept that we got in 2010, which is a service that's directed to the general public is a bona fide service from an advertising perspective. And I think the CFPB has confirmed that. Next slide. They also give us examples of MSAs that are prohibited. Some of these I think are pretty straightforward if you know the RESPA requirements, but nonetheless, I think it's helpful to see that from the regulator. So if we've got a marketing service agreement that's providing for payments that's tied to the number of referrals received, I think that should be a no-brainer. That's going to be a problem from a RESPA perspective. Anything that's above fair market value rate is going to be a problem. If it's an MSA that involves nominal services or the services that are outlined in the agreement are not actually being performed, that's going to create a problem. And then to the extent that the MSA just generally is a bit of a ruse to disguise payments for kickbacks that are happening in another form, then that's going to be a problem as well. Next slide. So what should we think about when we're talking about structuring compliant MSAs? So I think there's a couple of general things to keep in mind as it applies generally to 8C2, and then we can talk about some specifics from an MSA perspective. First, of course, is you comply with that two-part test. That's going to be the correct answer in every exam question as it relates to an MSA, is you have to comply with that two-part test. Another thing to think about is a business purpose. This is often something that comes up when we're talking about 8C2 arrangements in a more broader context. Are you trying to create particular services for a referral source to perform just so you can pay them? But there's really no reason for them to perform those services for you. Again, you're just creating an arrangement to satisfy, the relationship or solidify that relationship. Those kinds of agreements often lack a business purpose, and it could cause a regulator to take a look at it and say, you don't really need to pay them to perform that service because you do it yourself in every other transaction. That doesn't mean that it's illegal from a RESPA perspective, but it's one of those things to think about that regulators often raise when they are taking a look at an arrangement from a RESPA perspective. When we're talking about MSAs, I don't think there's a business purpose issue there. Any business and any industry needs to market itself, and it's going to spend its dollars in a way that has the most bang for the buck in terms of effectiveness from a marketing perspective. And of course, you want to advertise your services in front of a group of people who are in the market for your services. So I don't think MSAs suffer from a lack of a business purpose. One thing that folks like to do with MSAs that I think is a good idea is think about giving yourself a cushion. So if you know that fair market value is X, maybe you actually only pay Y to give yourself a little bit of a cushion in case your determination of fair market value were ever questioned. Of course, anything in excess is a referral fee. And then it's always helpful to look back at factual arrangements that the CFPB has taken issue with. I'm not going to get into those in particular now because the tips that we're about to go through, a lot of them are based on what we've seen from an enforcement perspective. So next slide. So let's think about particular do's and don'ts when you're looking at an MSA that you may already have in place, or you're thinking about putting together a new arrangement. The first thing is exclusivity. You should avoid exclusivity as part of an MSA. In the 2010 guidance that we got from HUD on MSAs, what they said about exclusivity is that it doesn't make an arrangement per se illegal, but it will cause the regulator to take a closer look on whether the arrangement is really meant to be compensating for referrals or if it's a true services arrangement. So from my perspective, don't give the regulators a reason to knock on your door and question it based on an exclusivity provision. So generally, I recommend that you avoid those. The second tip here is no endorsements. And by endorsements, I mean use of language like preferred provider or premier provider, or think of another adjective that folks use to set apart another company. The concern is that when you use that particular endorsement language, that you're paying for that endorsement, not for an advertising service. So again, it's better to just avoid adding additional language to your advertisements or asking the real estate broker or lender that you're partnering with to add that additional language, because again, the concern is that it's an endorsement that would be paid for. We've seen marketing services agreements in the past that have been part of CFPB enforcements that included provisions with the real estate broker to essentially put pressure on the independent contractor agents to send business to the company being advertised. And again, if that's written into an agreement where you're essentially locking in the realtor or a mortgage lender to cause their agents or employees to send business to you, it calls into question whether you're paying for referrals or you're actually paying for advertising services. Always avoid quid pro quos, whether it's in an MSA or another context. But if you are entering into a marketing services agreement based on an understanding behind the scenes that you're going to be referring business to each other, again, you've called into question whether or not that agreement is in fact payment for services or it's intended to be a referral arrangement. Don't use capture rates or return on investment to value the effectiveness of your MSA. There's no question, if you are the party paying for marketing services, that you're going to measure whether or not that's effective. You're not going to run advertisements in a publication that's targeting a market or a customer that would never need your service. And so you want to make sure that what you're doing is effective. However, whatever statistics that you're keeping at your business to be able to measure your marketing spend should not be a basis for discussions with the marketing partner about changing the rate that you're paying, changing the services that you're paying, or even ending the agreement. So that is something that has come up in enforcement actions in the past, where those capture rates or returns on investments were used to make changes to the agreement, and you want to stay away from that. Next slide. Independent third-party valuations. This is something that we recommend that folks do in connection with MSAs. It's not a requirement. If you look at the 8C2 two-part test, it doesn't reference an independent third-party valuation. But if you were ever asked to defend your calculation of fair market value, it's always helpful to be able to point to an independent third party who has no stake in your arrangement, has no stake in your business, who has looked at the services that are being performed and arrived at that fair market value calculation. So that's something that I think has become pretty commonplace in the market when it relates to MSAs. You certainly want to trust the partner that you are entering into the agreement with, but you also want to be able to verify the services have been performed. If we think about those FAQs we just went through, the CFPB highlighted that arrangements which services aren't performed are prohibited MSAs. So you want to make sure that the real estate broker or the mortgage lender that's advertising your title agency is actually performing the services before you pay them. So whether you require them to provide evidence to you on a monthly basis of the services they provided, or you go in or send an employee in to do the verification on your own, whatever it may be, that kind of verification is important to make sure you're not in a situation where you've made a payment to a real estate broker and they didn't actually perform those services. The next one, and we talked about this a little bit already, is all the advertisements need to be directed to the general public, not to individual consumers and not internally to real estate agents. Again, the idea is that it needs to be like a billboard. That's my best example. A banner ad on a website, physical signage at an office location, sign writers if you've got an agreement with a real estate broker as part of a for sale sign in the yard of a listing. All of the services are directed to the general public, and it doesn't involve an individual marketing directly to a consumer. To the extent that you are going to make changes in the fees that are paid under a marketing services agreement, you want to make sure you've got a legitimate reason to do so. Return on investment is not legitimate. We just talked about that. But if there's a change in services, then that is certainly a reason that you can make changes. If you intended for those sign writers to be on, 50 for sale signs, and then it turns out that the brokerage has grown in size and it actually is averaging, 100 or 200 new listings a month, that's an increase in service. And that would certainly be a reason why you could change the marketing fee to reflect that service. And then finally is disclosure. This is something that's encouraged based on that 2010 guidance that we got from HUD. And in that guidance, HUD essentially said, we think a consumer should know that when they see an advertisement on a real estate broker's website or signage displayed, that there is a paid relationship there, that it's not some sort of referral out of the goodness of their heart kind of situation. So I think providing a disclosure to a consumer is a good best practice. Whether it be the words, paid advertisement in the margin of a banner out on the website, or I've seen some real estate brokers will include a paper disclosure of part of their sales contract. So there's a variety of ways that can be done, but I think the key is making sure the consumer understands that there is that paid advertising relationship. All right, next slide. So co-advertising is something that comes up a lot in questions that I get from clients, where they talk about, particular instances of, wanting to co-brand marketing flyers or to do a co-branded newspaper advertisement or whatever it might be, and how do you incorporate that, or how do you think about that in the context of an MSA? And of course, joint advertising or co-advertising is where both parties are on the face of the advertisement, and those parties are splitting the cost of the advertisement based on their prominence in the ad. I don't generally think that co-advertising works in an MSA. That's not to suggest you shouldn't do it. Co-advertising happens all the time and is a good source of, I think, marketing efforts. But I think you should think about it separately than an MSA. An MSA really is a list of advertising services that the real estate broker or the lender performs for you. Whereas these are various opportunities that may come up where you are advertising together and you're both splitting the cost of that. So you might have a separate co-advertising agreement. You may choose to do it on a one-off basis, but I think you should think about them differently from an MSA. All right, next slide. All right, so let's transition to affiliated business arrangements. Prior to 1983, these were not permitted from a RESPA perspective. And of course, they can take many different forms. They can be what's often referred to as a joint venture, where in the example here, you've got two real estate brokers and a title agent that form ABC Title Agency. It could also be a wholly owned subsidiary. You may have a real estate brokerage that forms a wholly owned subsidiary that operates as a title agency. Regardless of how that is structured, when you've got a referral party that has an ownership interest or has an affiliate relationship with another settlement service provider, that's going to constitute an affiliate business arrangement. And so all of those need to meet the RESPA requirements. Next slide. When HUD issued guidance on affiliated businesses back in the 90s, they did so based on abuse, quite frankly. When that exception was put into place, the reaction of the market was to create shell companies that had no employees, there was no money invested into them, and it really was a way to just to funnel profits back to those referral parties. So there was guidance issued in the 90s that really, I think, became one of the primary features from a compliance perspective of an affiliated business arrangement. And even though HUD is no longer responsible for RESPA, and the CFPB has not issued their own guidance regarding affiliated business arrangements, our recommendation is those HUD factors to help measure bona fide affiliates are still a good best practice from a compliance perspective. Next slide. Which I basically cut. Well, before we move on, I basically walked through this one, but the one thing I do want to note is that at the bottom of the slide here, the Sixth Circuit does have litigation where they considered those HUD policy statement factors, and their conclusion was that they're not entitled to deference. So when you're talking about the law of the courts in Kentucky, Michigan, Ohio, and Tennessee, those 10 factors from HUD don't have any bearing from a judicial perspective. I don't think that CFPB necessarily agrees with that, and there's certainly litigations in other district courts across the country that have adopted that HUD 10 policy or 10 factor policy statement from a compliance perspective. So while I've heard that there are some pretty creative arrangements that might be happening from an affiliated business perspective in the states here in the Sixth Circuit, my recommendation still is that those arrangements continue to adhere to those policy statement factors, because I think that the CFPB does in fact think that that's the right compliance measurement. Next slide. So what do we need to comply with here? In all cases, no matter what state you're in, the three-part statutory safe harbor is an absolute requirement. And so the first requirement there is disclosure. There must be a disclosure provided by the party making the referral to the affiliated business that's on a separate sheet of paper. It identifies the affiliate relationship. It tells the consumer they're not required to use the affiliate, and it provides an estimate of the affiliated business charges. That disclosure can often be one of the more frustrating compliance pieces to the puzzle, because while it sounds pretty straightforward, if you're the title agency that owns 50% of a joint venture title agency with a real estate broker, you're reliant on that real estate broker and its agents to make sure that disclosure is provided every time that a referral is made. So it's, I can't emphasize enough how important that component is. And it often can be one of the requirements that can trip up a business if there's not good controls around making sure that disclosure is provided. The second requirement is no required use. So a real estate broker, and we'll just continue with that example, a real estate broker that owns an interest in a joint venture title agency, they cannot require their customers to use that joint venture. They could offer an incentive from a RESPA perspective, although we've got state law considerations as well. But if they offer an incentive, that's not a RESPA issue. It's not considered required use. But again, there could be state law considerations there. And then finally, from a statutory safe harbor perspective, any returns or distributions that are made to the owners in the business must be based strictly on their ownership interest. So if the real estate broker and a title agency each own 50% in a joint venture title agency, both parties are entitled to 50% of the profits. Doesn't matter that the real estate broker sends 100% of that entity's business, they still get the 50% based on their ownership interest. No payments based on volume of business. Again, like I said, if the real estate broker is responsible for all the referrals into that business, real estate broker still gets the 50% ownership. You can, however, pay for services. So if the real estate broker, for instance, is leasing space, office space to the joint venture, you could pay them for the lease of that space. Next slide. The 10-point test that I mentioned, again, these are factors that regulators would weigh to evaluate whether the affiliated business is bona fide. You don't necessarily have to meet all 10. There's no magic formula that's provided to us in the guidance over the years about which of the 10 are necessary to evaluate an affiliated business. But of course, the more of these factors that are satisfied, the easier case it is to make and defend the affiliated business from a RESPA compliance perspective. That's going to cover capitalization, which generally our recommendation is an affiliated business should be capitalized with enough cash to operate for several months without income. So 3 to 4 months of no income, I think, is a good measure. Dedicated employees. The policy statement factors balance that. Is the employee dedicated to the joint venture, or are they shared employees? And the compliant practice is employees dedicated to the venture. So if it's a joint venture title agency, maybe that if you're in a state where that individual needs an insurance producer license in order to do title, the joint venture needs to employ a person with that license who can do those services. Separate office space is another factor. It can be leased from a partner, again, assuming that the rent that's paid is fair market value. The employees that are dedicated to the joint venture must perform the core services of the business. When we're talking about joint venture title agencies, it's easy to know what those core services are, at least from the regulator's perspective, because we have a definition in the regulations of what core title agent services include. So the employee that's working for that joint venture title agency needs to perform those core services. That means they need to be able to review a search package to determine the insurability. They need to prepare and issue a title commitment. They need to clear underwriting objections, and they need to issue a policy. And if you're in a state where the title and premium also includes closing the transaction, Pennsylvania is an example, then the joint venture employee needs to perform that service as well. From a management perspective, the joint venture needs to manage its own day-to-day activities. So, if you've got dedicated employees who are working from the office space, they're taking care of the day-to-day issues. It is fine from a compliance perspective for a joint venture to subcontract administrative functions. So whether it's accounting or human resources or technology support, those are the kinds of services that a business, of course, needs, and they can be subcontracted to a partner in the business, or it could be an independent third party, whatever works best for that particular venture. The joint venture also needs to engage in marketing. It needs to attempt to obtain business from an outside source. There's no requirement under RESPA that a joint venture actually receive business from an outside non-affiliated source, but the more business that's obtained from an outside source, the easier it is to make the case that you've satisfied that marketing factor as it relates to affiliated businesses. And then exclusivity with owners. In the title insurance context, this often comes up when you have a title agency that's owned by an underwriter. If that's the ownership structure, the title agency can't send every title insurance policy to the underwriter. In fact, they can't require the use of the underwriter. So that's an extra consideration from a title entity perspective. Next slide. Affiliated business arrangements have been popular from an enforcement perspective with the CFPB. This is just a couple of bullet points here on various structures of affiliated businesses that have been deemed non-compliant from an enforcement perspective. And you can see that it hits on both the statutory safe harbor as well as those 10-point factors. So if owners receive distributions based on referrals, that's an issue. And I'll give you an example of an enforcement action that doesn't just apply at the direct ownership level, it also applies at the indirect level. So if you've got a group of real estate brokers, for instance, that form an LLC, and that LLC holds the 50% interest in the joint venture, the LLC is going to get its 50% profit distributions. But when the LLC distributes profits to those individual brokers that are owners of that business, that also needs to be done strictly according to ownership interest. Just because we're one step removed from the joint venture doesn't mean that those profits can be distributed however the owners want them to be. Capitalization has been an issue. The office space, whether the employees are leased or dedicated. Essentially, if you look at those factors, there's been some enforcement action where a business has not met them, and that has caused regulators to take enforcement. Next slide. So let's talk about some considerations for compliant AFBAs. We've actually gone through a lot of them as I was talking about the various HUD factors, but I think that there are several of them that bear repeating from an enforcement perspective. Disclosure, I always put disclosure at the top of my list. In every case of a referral, the disclosure has to be provided, and has to be provided at or before the time of the referral. I think it's often a good idea for joint venture title agencies, if they have a real estate broker as an owner, or even a lender as an owner, to require copies of that affiliated business disclosure to be provided when you're opening a title order. That gives you the assurance that that person who's being referred to your business did in fact receive that disclosure. As I mentioned, closing cost incentives are okay. When we're talking about title insurance, though, of course, you can't forget the state anti-inducement provisions and how that might impact your ability to do that. Distribution strictly according to ownership interest. I think we've gone through that one. The investment of sufficient capital to operate the business. So I mentioned before that we recommend enough cash to operate a business for 3 to 4 months without income. And I'll often have clients say to me, how do we even figure that out? And my response is, think about your expenses. Are you going to hire 3 employees to start? Are you going to hire 1 employee to start? What's your monthly rent going to be? How much is it going to cost you for technology licenses and the other software that you need to operate the business? What are you investing in terms of equipment and furniture to outfit the space? What are your marketing dollars going to be? All of those expenses go into the startup cost of a business. And if you're going to pay them for 3 to 4 months, that starts to build that number you should think about from a capital perspective. We talked about the dedicated employees working from the office space. In this time of COVID, when so many of us are working from home, I often am asked, well, do we really need to have an office? Can't our people just work from home? And to the extent that your joint venture is a business that does receive the public, whether it be because you're closing transactions or you're located in the real estate broker's office so that you have that convenience to meet with customers, you still need to maintain that office space, and maybe there is some adjustments that you can make in terms of office hours to meet with consumers when the majority of the time is spent at home. But I think, again, the concept from a RESPA perspective is that you're operating your business the way a bona fide independent title agency would be offered. And so whatever is your practice to serve your customers at this time, you would want to replicate that for a joint venture as well. The employees should perform the core services. So that includes those core title agent services that I mentioned. I'm also often asked by clients about, what do you do about overflow? So if we're a small joint venture and we really only have enough volume to support 1 or 2 employees, what happens if they're both sick? Or what do you do when one's on vacation and the volume is so much that that other employee can't keep up? And the answer is that you can look to others to provide overflow support. So if you're the title agency owner in a joint venture, maybe you have an agreement with the joint venture that allows you to provide and perform those core services from an overflow perspective. But the key is that it's an overflow perspective. You're not on the regular performing those core title services for the joint venture. The joint venture's employees needs to do that. The other issue that often comes up with joint ventures is, what do you do when you want to add members? What do you do when you want to remove members? And while this is an issue that's not necessarily grounded in the statutory safe harbor or the 10-point factors, it's still a RESPA consideration, because the granting of stock or even the opportunity to participate in a money-making venture is considered a thing of value. So if there are real estate agents in your market or real estate brokers in your market that you think would be excellent partners, and they, create a joint venture with you, at the end of your first year, if one broker referred substantially more business than the other broker, you can't reward them for that with additional stock in the business. And you can't do that by creating more stock or by removing the member who wasn't a good referral partner. So, once you set up that venture and you think about how adjustments might need to be made from an ownership perspective, just remember that referrals should not be the reason while you're making those adjustments. All right, next slide. So I would be remiss to talk about all of this from a compliance perspective under RESPA to not also mention state law, particularly when we're talking about title insurance. Even if you've checked all the boxes from a RESPA perspective, there still may be laws in your state that prohibit or limit what you're trying to do. In the affiliated business context, there's often, well, I won't say often, but there's at least a dozen states or so that have controlled business restrictions that put percentage limitations on the amount of business that a joint venture can earn from the referrals of an owner. So California is an example, Tennessee's an example, Utah's an example where those kinds of restrictions are in place. The other thing is just your state anti-inducement laws. There are some states where those laws are pretty strict, and a marketing services agreement may not be possible. Washington State is an example of that, where they have a pretty explicit advertising requirement that prohibits real estate brokers or other referral sources from being paid to advertise a title entity. So even if you've structured something to be perfectly compliant from a RESPA perspective, state law may disrupt what you're trying to do. So it's always important to be aware of what those restrictions are and how it impacts what you're putting together. So with that, I am ready for questions if you've got them.
Hey, thank you, Holly. Yeah, we do have some questions that rolled in, but great discussion on compliance and the do's and don'ts on marketing service agreements, AFPAs, joint ventures. Had quite a few roll in. Just a reminder, we can't provide explicit, legal advice. If you have, questions about your arrangements, seek counsel. Terry asked about an advertising question and about a third-party web company, ABC Inc., leases out their domain to that is commonly searched. They bill the realtor who appears on the main web page for the majority of the monthly expense. Then the title company tab and the lender tab link to their websites. So they pay smaller portions of the bill. Is this okay since all parties are joining in to pay proportionally the advertising?
So what I think was just described there's these tech companies out there that will create a website for a real estate broker, like, findhomesinAtlanta.com. And so the web page operates as the real estate broker's web page, but then they're selling advertising on that page essentially. So I think you do have to think about it like the sale of an ad. So if there's a tab on the real estate broker's web page that includes, title agency banners or logos, you can certainly pay for the cost of that advertising or the fair market value rate for that advertising.
It's probably not going to be split by thirds though, right? You're going to pay portion.
Correct, that's right. Even though we're talking about a web page, which can get tricky when you're trying to figure out prominence, right? Like you want to make sure you're paying in proportion to your prominence on the web page, but which can get tricky, but that's still the general guideline when you're looking at how to share that cost.
Okay. Had a couple of questions on how to, if they can, I'm not sure if this is affiliate businesses or a question if they can pay commissions to, if they had to be a bona fide employee versus a 1099 contractor. Can they pay commissions to those people?
So this question sounds like it might be related or similar to an arrangement that actually was an enforcement action with the CFPB, where a person was purportedly employed by a title agency to go out and market and generate business for the title agency, even received a W-2, but then their payment was commission splits on the deals that person brought in. The CFPB took the perspective in that enforcement action that person was not an employee. Even though they were paid on a W-2 basis, they weren't subject to the supervision and control of that title agency. So when you think about that structure and it's 1099 versus W-2, definitely needs to be somebody that's a W-2 who is an employee of your business and who meets all of the indicia of employment, right? Not just a W-2, but they really do operate like an employee for your business.
Okay, all right. This is an interesting question from Josh. He asked, how cumbersome costly is a typical defense of an MSA?
Say that again.
How much does it cost to defend it? I guess if you're found to be in violation.
Yeah. So unfortunately, it can be costly. The CFPB's enforcement regulations were modeled off of the Securities and Exchange Commission. So, think formal discovery, unfortunately. You'll get a civil investigative demand. You're producing documents that have to be, meet all of the e-discovery requirements. You're likely looking at depositions. Just the cost to maintain the data and not destroy and delete it on a recurring basis can add up depending on how long those investigations take. So it can be costly to have to defend one of those.
Mm-hmm. And then there's another question. So RESPA violations, CFPB is they oversee that. So, if there's a violation, that's where the reports of abuse are going to be sent to, right? Correct?
That's right. The statute also gives state insurance departments the authority to directly enforce Section 8 of RESPA as well. So yes, it could come from the CFPB, but it also could come from your state regulator.
Okay. We've got a lot of questions on really specific scenarios, so we're not going to be able to get to all those. I apologize. We are at the top of the hour. We'll try, Holly, you want to we'll answer a couple more and then we'll wrap it up. Question from Ken wants to know if the title company is liable if the independent real estate agent does not provide disclosure.
So it impacts the venture as a whole. So because you're both owners in the venture, if the affiliated business itself doesn't meet the requirements, one of which is the disclosure, then yes, all of the owners in the venture could be held liable for that violation.
Okay. And then when you were talking about required, Michael asked, they strongly suggest it. Is there wiggle room in what you can say, or it needs to be pretty much bright line that, hey, you are not required to use this affiliated company?
Right. So the regulations provide a model affiliated business disclosure form, and so that includes very explicit language. You are not required there to use this provider. There are often other settlement service providers with the same service. You should shop around. So that language is pretty explicit, and we do recommend that companies use that model form for their affiliated business disclosure form.
Okay, and we'll wrap up with this one. This is kind of interesting as more transactions occur digitally. So Kelly asked, a real estate broker has an affiliated business arrangement with a title company in a different geographic location. Do they still need to have a physical employee in the broker's office, or can the title company use a remote notary for the closings?
Right. So yes, I mean the remote notary, depending on what's typical practice for title and closing agents in that location, that's totally fine. From a RESPA perspective, the key is the core title services. So it's the work to examine and issue title policies that are the most important factor from a RESPA perspective.
Oh, seems like a lot of it comes back to that 10-point test.
It does.
All right. Well, I think we're going to wrap up for today. Just as a reminder, if you missed parts of today's webinar, I think others in your office would benefit from listening. Recording the presentation will be emailed to everyone. And again, you can always find our webinars archived at altca.org/webinars. I do need to thank SoftPro once again for sponsoring today's webinar. And that will bring us to the conclusion of today's presentation. Holly, thank you again for sharing your insights and helping our members comply with RESPA.
My pleasure. It's great to be with you.
All right, thank you. Take care, everyone.